Good morning. Good morning, my friends, and thank you so much for coming to spend part of your Thursday, October 3rd with me. Wow. September ended. Wake me up when September ends. It's gone. And I didn't even really realize it. But here we are in October. Today is Rosh Hashanah, so Happy New Year. Shana Tova to anyone of my friends who are celebrating today. And it is a court holiday as well, as we have learned in some parts of the country. Anyway, today we have a lot of things to talk about. There's so much to cover. I just didn't even know where to start. We have some new documents that were filed on the Karen Reed civil case, the O'Keefe versus Karen Reed, CF McCarthy's and Waterfall wrongful death lawsuit. And we have the fee agreement for Hank Brennan, who has been hired by the Norfolk County District Attorney's Office to re-prosecute or persecute Karen Reed in the upcoming retrial, which is scheduled to start January 27th of 2025. So that's interesting news. Then later today, I've already set it up for 12:30. I'm going to be doing a show on this crazy story out of Kentucky. The sheriff that shot the judge. It's crazy. And I know you guys wanted to catch up on that with me. So we're going to do that at around 12:30 Eastern today. And somebody just said in the chat here that it has been 3 weeks since the death of Enrique Delgado Garcia at the Massachusetts State Police Training Academy. And still, it's nothing. Shalom, shalom. Private info. Right? Is that crazy? Shana Tova, Martha. It's crazy. We've got nothing. We've got no more information on Enrique than we did 3 weeks ago. Unless anybody's heard something that I haven't. It is shameful. 100% shameful, Sharon. 100% shameful. Where to start? Where to start? Where should we start? Maybe we'll start with Hank Brennan. We also covered the Brian Walsh hearing yesterday. They want all of the information on Proctor. I have the motion papers. I want to go over them with you at some point, but not during this stream today. Then I saw something crazy too. There was a Massachusetts state trooper injured on Monday night. And I can't confirm or deny this, but did anybody hear like a rumor about who that Massachusetts state trooper was that was involved in that drunk driving crash? Anybody hear about that? I'm going to put it up for a second. Here's the article from Boston 25 News. Massachusetts trooper injured after cruiser struck in highway crash involving alleged drunk driver. It says a Massachusetts state police trooper was injured after his cruiser was struck in a highway crash involving an alleged drunken driver on Monday night. That was October 1st. The trooper was inside his cruiser at a work detail on Interstate 90 near mile marker 126 in Newton when a Subaru Forester rear-ended his vehicle, according to MSP. The trooper, whose name hasn't been released, was taken to a local hospital for treatment. The Subaru driver, well, they name her, 45-year-old Kimberly Anderson of Pittsburgh, Pennsylvania, was arrested on charges of driving under the influence of liquor, state police says, and it says the crash remains under investigation. Anybody know anything about that? Anyone? Somebody said it was Trooper Reno, that it was Trooper Reno. Is it true? Is that true? Do we have any? Guarino. Good morning, Kelly Reed. Good morning, Kelly Reed. Kelly Reed in the house, everyone. Some sources say it was him, but if he's the forensic cellular guy, why would he be out doing like work detail in his cruiser? I just have questions about that. So if anybody's got any information on that, Let me know. I thought he was like an office guy who did, cell phone extractions and stuff. So you tell me. Aiden had a sauce? Aiden had a sauce? Why wouldn't they put his name out there? I don't know. The whole thing seems very interesting. He was working a detail out of Mullally's resignation. All right. Well, I can't confirm or deny, but I did hear that rumor as well. So probably overtime detail. It's crazy out for dinner and cocktails. Oh, all right. Justice is Truth 444. In Massachusetts, they all sit along the highway in their vehicles. That's what they call detail in Massachusetts. Well, I mean, that's interesting. It's a good time to point out that the opinions of my viewers are not necessarily my own opinions. Let's take a look at Hank Brennan's contract because it's public record and all. And quite frankly, I think it's a bargain. And I think I have questions. I have a lot of questions about this contract. Let's pull it up. Or not. Hello. Hello. Alrighty then. Aiden said the person that hit him was named Karma. Karma's got your address. That's what they say about things and stuff sometimes. Okay. For those of you who know, for those of you who don't know, I will tell you that the Norfolk County District Attorney's Office has decided apparently that Lally didn't do a good enough job in the first mistrial of Karen Reed, in which allegedly the jury acquitted her on murder charges and on the charges of the charge of leaving the scene of the accident, but wasn't reported in open court or even asked about in open court. So now that has gone up to the appellate court in Massachusetts and will be heard by the full panel, whether or not she was acquitted, whether that would be double jeopardy to try her again, whether the jury should be called back in and questioned about whether or not they did actually acquit her. And so the Norfolk County District Attorney's Office has decided to hire outside counsel to come in as special ADA. And they have hired a man by the name of Hank Brennan, who is a criminal defense attorney who has represented defendants in high-profile cases, including Whitey Bulger. The irony is not lost. It is not often that a defense attorney is hired to come in as special prosecutor, special ADA, because defense attorneys in private practice make a lot of money. And I'm not sure why they would give up practicing for however many months it is to come and prosecute a case that has already resulted in a mistrial, a potential acquittal on 2 charges, and quite possibly it could be the most ridiculous trial that we've seen thus far in, let's say the 20s, in the 20s. So this is very strange. So here's the standard contract form for the Commonwealth of Massachusetts, and they are contracting Brennan and Associates out of Boston, Massachusetts, on 20 Park Plaza. And it is a new contract here, as you see on the left. That's the boxes checked. Hired by the Norfolk County District Attorney's Office. This is a maximum obligation contract, which means that the most that they will pay during the term of this contract is $75,000. And what I find so strange about this is that Hank Brennan is only billing at $250 per hour, as you can see right here. $250 an hour with a max payout of $75,000. And the contract is going to terminate as of June 30th of 2025. Okay. So the date of this contract, September 10th. When did this news break? Guess they kept it on. Well, it wasn't signed. Okay, it wasn't signed until the 23rd of September. $250 an hour is like at least only 1/3 of the usual hourly rate of Boston attorneys, I will say. $750 an hour would be even light. In LA, some divorce attorneys are charging $1,500 an hour. Why so cheap is right. I have no idea. And especially if the contract is going all the way through June of next year. It's like a 9-month contract. And at $250 an hour, that only gives him 300 hours. Okay. He wouldn't even be able to review the trial transcripts in 300 hours or the file. Like the whole thing is, it's crazy. The rest come in unmarked white envelopes, says Kate. That's a bargain basement price. Why would a high-powered criminal defense attorney give up their practice for 9 months for a maximum compensation of $75,000? It just doesn't make it. It strains credulity. It strains credulity. How much money did Nathan Wade make in the Fonnie Willis case? Like over $450,000, I think. Call me Alice, but I'm in the rabbit hole of why he would do this. Thoughts, concerns? Yep. Moon Goddess is like, inquiring minds want to know. I'm tired of Massachusetts taking my tax money to do whatever they want to do. Well, apparently they don't have very much faith in their own district attorney's office and all of the attorneys that work there to think that they can do a good enough job that they have to go out and hire what they are calling a special ADA to the tune of 75 grand. Yeah, the contract can be renewed once money is used up. I will tell you that I did the math. 300 hours, assuming only a 40-hour week, is only going to last 7.5 weeks. So we're in October. It's going to take him through Thanksgiving. And then what? Is it just to keep the peace among the people and the residents of Massachusetts and Norfolk County that they're spending this money on an outside attorney? Patty says he's obviously taking this case for fame. He doesn't need it, though. That's the thing. He doesn't need it. He doesn't need it. Why give up your practice? $75,000 for 9 months? I mean, do the math. It's $25,000 a month. That's like a base salary of 100 grand a year. I'm sure that he makes, 10 times that, maybe. Who knows? 8 times that, 7 times that in private practice. Why would he do it? I don't know. I have questions. Kim says Marcy wants her convicted and will do whatever he can to make sure it happens. I don't know. Giovanni's Pikachu says more than likely some kind of back-end compensation we won't ever see. I don't know. I don't think it's for fame. I think he doesn't need it. I just think it's bizarre. It's a very, very low rate. Their staff attorneys make, well, not much, but Lally makes, well, I don't think, you're right. I don't even know if Lally makes 6 figures. But I don't understand why he would do it. I have a lot of questions about that. But in any event, let's move over to let's go to Plymouth County to talk about the filings that have happened in the O'Keefe versus Karen Reed case. So many of you asked me to go over CF McCarthy's answer, but there just wasn't a lot to say about it. It's pretty much very standard. So I was kind of waiting for some other documents to drop, and they did drop yesterday. They were filed yesterday, so we can talk about them in their order of filing. The first is the answer from CF McCarthy's. CF McCarthy's appeared by counsel in the case around September 20th. Their answer was filed. I will pull it up for you and we can take a look at it because that's what we do here. We do documents. Good morning to Oklahoma. Good morning. Look at 2,000 people up and about before 9:30 a.m. on the East Coast. Good on you guys, getting up early, getting it done, getting to work. Not really working because you're listening to me, but right on. Here's the answer. That defendant's CNC Hospitality, DBA, CF McCarthy's filed on September 20th. As you may recall, the lawsuit filed against Karen Reed, McCarthy's, and the Waterfall is alleging such things as wrongful death, intentional infliction of emotional distress, dram shop action against the bars who served Karen allegedly got her drunk enough to strike her boyfriend, Boston police officer John O'Keefe, with her vehicle, which, in my opinion, with my over 30 years of civil litigation experience, including but not limited to handling pedestrian motor vehicle accidents, I can tell you with 100% certainty that the injuries to John O'Keefe do not match up with a pedestrian collision at 24 miles an hour. They just don't. They just don't. So good luck with this civil suit. The plaintiffs are Paul O'Keefe as personal representative of the estate of JJ, as they call him throughout the lawsuit. Paul O'Keefe individually, John O'Keefe the father, Margaret or Peggy O'Keefe the mother, and Kaylee the niece, who I did not think was necessary to drag her through any more court proceedings or litigation, but nobody asked me. If you'd like to catch up on the original filing, the complaint, I have linked that stream below so that you can do that, because I don't see a need to review it here. Here is their answer. Defendants CNC Hospitality, DBA, CF McCarthy's hereby respond to the allegations in the complaint in this action. CF McCarthy's reserves the right to supplement its answer as warranted by the circumstances and as allowed by law. All allegations not specifically admitted are denied. Footnote 1. The entity GNS Hospitality LLC has no affiliation to CF McCarthy's, and therefore is not a proper party to this lawsuit. By filing this answer on behalf of this entity, no acknowledgement or admission is made that it is a proper party to this lawsuit, and all rights are reserved accordingly to seek dismissal of GNS Hospitality. Oh, that's interesting. So I don't know what, if anything, GNS had Hospitality ever had to do with CF McCarthy's. If it was purchased by CNC Hospitality, but they're saying they have nothing to do with us, and therefore we're not answering for them, and we're going to move to dismiss at a later date if you don't voluntarily discontinue, pretty much. So this is what an answer is. We looked at the complaint, which has very many paragraphs in this case. And what you must do as a defendant when you answer a complaint is you must either admit or deny each individual paragraph as set forth in the complaint, or deny knowledge and information sufficient to form a belief as to the truth of the allegations in that paragraph. So you have to go through the complaint paragraph by paragraph and address each paragraph. And anything that you admit would be something that is stipulated to and not at issue in the final civil case. So first they talk about parties and jurisdiction. And that's why this is really not very interesting. So they believe that Paul O'Keefe was the brother of the decedent. They admit that John O'Keefe was the second, was the father of the decedent. Upon information and belief, they admit that Margaret O'Keefe was the mother of the decedent. And so they just go through paragraph by paragraph by paragraph. And there's really nothing interesting or novel or exciting about this, because most of it, they say, we don't have any information or knowledge. We lack sufficient knowledge or information to admit or deny, and therefore leaves the plaintiff to their proof. Meaning, we don't know if this is true or not, so you're going to have to prove it. And that goes for pretty much every paragraph, except for they do admit that John O'Keefe was present at McCarthy's on the evening of January 28th. They admit that they served Karen Reed alcohol or other beverages on January 28th of 2022. But they're not going to admit that she was drunk or they served her 9 drinks or whatever it is that they're alleging in the original complaint. And paragraph 29, it says, to the extent the allegations in this paragraph insinuate that C.F. McCarthy's alleged conduct rendered Reed unable to drive a motor vehicle safely, such allegations are specifically denied. Everything else, they're like, prove it, prove it, prove it. Except for to the extent that the paragraph insinuates that C.F. McCarthy's alleged conduct rendered Reed in a state of intoxication, such allegations are specifically denied. Prove it, prove it, prove it. Prove it, prove it, prove it, all the way to paragraph all the way through paragraph 53. Count 1. There's a denial of paragraphs 55 through 59, all the way through 63. And this is just a whole bunch of legal mumbo jumbo that basically says the only thing we're admitting is that Karen Reed and John O'Keefe were at our bar, that we did serve Karen Reed beverages, alcoholic beverages. However, she was not intoxicated. She was not unable to drive a car. She was not impaired. We didn't do anything wrong. And it's pretty boilerplate. Except for the things that are outright denied. And what you would do as an attorney, you would make marked pleadings. So you would take your complaint as the plaintiff, and I'm a plaintiff's attorney. And when the answer comes in from C.F. McCarthy's, you would go through your complaint and you would write in the left margin, or I would anyway, D for deny, A for admit, or DKI, deny knowledge or information, for every single paragraph in the complaint. So as much as I would love to or wanted to go over this with you, there's really just nothing here out of the ordinary, except that you can bet that they're on the same team as Karen Reed, because obviously they don't want to be found liable. They don't want to pay. And in the end, they ask for attorney's fees, which is also common. There's nothing unusual about that. I saw some people squawking online about it, but there's just nothing out of the ordinary here. Let's see the end. Okay, so then they put forth their affirmative defenses. First affirmative defense is that the complaint and or its respective causes of action against C.F. McCarthy should be dismissed pursuant to MRCP 12B for failure to state a claim against C.F. McCarthy's. It just basically says you have no right to sue us. There's no cause of action here. That is a very standard affirmative defense in almost every single case. The second affirmative defense says the complaint is barred in whole or part by the plaintiff's failure to comply with the statutory prerequisites for bringing a cause of action based on the distribution, sale, or service of alcoholic beverages, also very common in a dram shop action. Third affirmative defense, the plaintiff's claims are barred in whole or part for failure to comply with General Law Section 231, Section 60J, which I honestly did not look up, but I can if you want me to. Fourth affirmative defense, no acts or omissions of C.F. McCarthy's, if any, were the proximate cause of the plaintiff's alleged injuries and damages, and said injuries and damages, if any, were the result of other intervening and superseding causes for which CF McCarthy's is not legally responsible. And that may mean that they're just either going to try and say, she didn't get drunk here, she got drunk at the waterfall, or she didn't do this at all, some other people did. Fifth affirmative defense. The plaintiff's claims are barred in whole or part to the extent that plaintiff's alleged injuries and damages were solely and proximately caused by the intervening negligence, gross negligence, wantonness, recklessness, willfulness, or otherwise careless, willful, intentional, and or criminal conduct of an independent third party for which CF McCarthy's is not legally responsible and or exercised no control. Kind of like a third-party culprit affirmative defense. IYKYK. Rubber duckies. Sixth affirmative defense. To the extent that CF McCarthy's owed any obligation or duty to the plaintiffs and or John O'Keefe III, such obligations or duties were fully, completely, and properly performed in every respect. Seventh affirmative defense. At no time did CF McCarthy's purported conduct violate general laws section 138, section 69, in that it did not cause any alcoholic beverages to be sold or delivered on any premises to an intoxicated person, meaning Karen Reed or John O'Keefe. Eighth affirmative defense. CF McCarthy states that it presently has insufficient knowledge or information on which to form a belief as to whether it may have additional yet unstated affirmative defenses. CF McCarthy's reserves all rights to file an amended answer asserting additional defenses or to file counterclaims in the event that developments and or discovery in this litigation so warrant. It's basically like a catch-all phrase saying, we reserve our right to supplement this at any time if we just decide that we discover that we have any other affirmative defenses. And so therefore, just because we didn't plead it right now, it doesn't mean that we're waiving anything that we may find out in the future. They put in a jury demand. And then they asked that the court dismiss the plaintiff's complaint and that it award CF McCarthy's its reasonable costs and attorney's fees incurred in the defense of this action and such other further and relief as the court deems just and proper. XOXO, attorneys for CF McCarthy's, Peabody and Arnold. This was dated and filed in Plymouth Superior Court on September 20th of 2024. I did not see an answer yet from the waterfall, as of yesterday anyway. So that remains to be seen. There also is no answer from Karen Reed's team. However, they have made a motion in lieu of an answer, which is another way to answer a lawsuit. So that's exciting for us to learn about today. Why Plymouth? They filed it in Plymouth because that is the residence of Paul O'Keefe. Basis for jurisdiction, at least in New York, I can't say that I'm fully familiar with Massachusetts law, but basis for jurisdiction is usually either the plaintiff's residence, county of residence, or the defendant's county of residence, or where they do business. So I don't know where does Karen live? Mansfield? I don't know what county that is. But Peggy and Mr. O'Keefe, I believe, live in Norfolk County. So they could have filed it in Norfolk County, but they chose Plymouth for some reason. And that's a good question. Why would they choose Plymouth over Norfolk? I don't know what the judges are like there. If there's anybody in the chat who knows, let me know. Good morning, Lisa C. Thanks for joining us this morning. Hello, Thomas. Can't wait for Waterfall's response about that night. Thanks, Thomas, for the deuce. Weird Ryan became a member. Welcome, Weird Ryan. Thanks for your super sticker. On top, as always, on top of the super stickers, Mark Cunningham, thanks for the 5. He's got to make money for his family before he goes down. Couldn't find 33,000 texts. Come on, man, so corrupt. Hope you're well. I don't know. He's got to make money for his family. Oh, you talking about, are we back to Trooperino? Or are you talking about Hank Brennan? I think you're talking about Trooperino. Trooperino. That's why he was doing detail on the road, making some overtime. I don't know. Thomas, Brennan pay is as if he will only try 0 of 1 charges, even so, if that is true, the trial prep alone on this is far greater than 300 hours. I mean, think about how many months the last trial was. I mean, it's just crazy. 300 hours is like nothing. Thanks, I'm Just a Girl in the World, for gifting 5 memberships. You're so sweet and kind and generous. And for those of you who were awarded them, congratulations and welcome. Mike Ray, thank you for your super sticker. Appreciate you this early morning. Yeah, Kevin Albert gets 10 weeks of paid vacation for being a creeper, you know. You're funny. You guys are funny. All right, I have all the documents here. Let's just see if I can pull them up in the proper order. The first one is number 17, 17, 18, 19, 20, 21, 22, 23. All right, first up, defending Karen Reed's motion to stay the civil proceedings. Somebody said in the chat earlier, what does that mean? It means they want to halt the civil proceedings. A stay is like a freeze. They want to freeze. Let's take a look and see what it says. This was just filed hot off the presses, my friends, yesterday at 3:42 p.m. in Plymouth County. There's your docket number. It's stamped received. Same caption. Defending Karen Reed's motion to stay civil proceedings pending resolution of criminal trial. This is what they call a motion in lieu of an answer. So they have not yet answered the complaint. They're filing this motion instead. I'm going to be reading, so I can't see the chat. So save your questions if you don't mind until we get through this. And this, my friends, is your cursor, my cursor. It's my cursor on your screen. Do not break your television and send me a bill. Thank you. The defendant, Karen Reed, respectfully requests a stay of this civil action until conclusion of the pending criminal trial in Norfolk Superior Court. The criminal trial involves the same circumstances alleged in this civil matter and is scheduled to begin on January 27th of 2025. A stay is appropriate here, where proceedings with this civil action at the same time as the criminal action will adversely affect Ms. Reed's Fifth Amendment rights and her ability to vigorously defend herself from criminal prosecution. The requested stay involves minimal delay and is not prejudicial, as the civil tracking order contemplates an August 2026 discovery deadline, an August 2027 disposition date. I'm here to tell you that the wheels of civil justice turn very slowly indeed. In New York, we call them standards and goals. I mean, you have standards and goals for when you're supposed to be able to finish all of your discovery and wrap up your case. And this is a pretty generous deadline of August 2026 for discovery and a 1 year later for disposition by trial, motion, or settlement, verdict, or otherwise. Massachusetts law indicates that a stay is appropriate in such circumstances. See MK v. DB 2023 case, which says in the event of parallel criminal and civil cases, the civil action often will at least partially be stayed until the criminal case has concluded. Pursuant to Superior Court Rule 9A, A1, a supporting memorandum is filed together here with a hearing is respectfully requested. Let's take a look at the memorandum. Here's the memorandum of law in support of defendant's motion to stay. Compared to what we're used to, these are short. This is only 6 pages. Memorandum of law in support of defendant's motion to stay. Defendant Karen Reed respectfully requests a stay of this civil action until conclusion of the pending criminal trial in Norfolk Superior Court, which is scheduled to begin on January 27th of 2025. On balance of the parties' competing interests, the relevant factors, and Ms. Reed's Fifth Amendment privilege, a stay is both warranted and essential here. Hold on, I would like a continuous scroll, please. One moment, please. Hold, please. Thank you. Legal standard. The decision to stay a civil action pending the outcome of criminal proceedings is in the discretion of the presiding judge. In considering a request for a stay, it would constitute a clear abuse of discretion for the judge to turn a deaf ear to a serious claim of privilege. The privileges afforded to Ms. Reed under the Fifth Amendment would be substantially impacted should this action proceed while the criminal prosecution is ongoing. And that is an excellent argument because she should not be forced to give a deposition in a civil case while her criminal case is pending, and she has the right to not testify at her criminal case. Very common motion, should be granted, but we'll see. Given the discretionary nature of the court's role in ruling on a motion to stay, the decision to grant a stay ultimately requires and must rest upon a particularized inquiry, I'm thinking of injuries now, a particularized inquiry into the circumstances of and the competing interests in the case. This inquiry involves a balance of the prejudice to the other parties against the harm to Ms. Reed, should she be compelled to choose between defending the civil action and protecting herself from criminal prosecution. The inquiry on a motion to stay involves consideration of other competing factors as well, which Massachusetts courts have derived from federal courts. Such competing interests include, amongst others, 1, interests of non-parties, 2, public interest, 3, overlap of the issues, 4, procedural status of the criminal case, and 5, interests of judicial economy. See Precision Testing Labs v. Preventative Medicine Associates. Citing trustees of plumbers and pipe fitters versus Transworld Mechanical, and a couple of other cases. And then they go so far as to even include the Superior Court decisions as Exhibit A, which is a very nice thing to do for the judge, because then the judge or the judge's law secretary does not have to look those up, him or herself. Argument A balance of the potential burden and prejudicial efforts weigh in a favor of a stay. There will be no prejudice to the plaintiffs nor to the co-defendants should this brief stay be granted. To the contrary, Ms. Reed's ability to vigorously defend herself from criminal prosecution will be substantially prejudiced should this civil litigation proceed while her criminal trial takes place. The only potential prejudice to the plaintiffs is the inconvenience of a brief time delay. That inconvenience does not outweigh the importance and interest in protecting a defendant's constitutional rights. Moreover, the court's tracking order allows for discovery up to and including August 17th, 2026, and sets forth the final disposition date of August 26, 2027. See Exhibit B. The parties will have ample time to fully discover the facts concerning the allegations and defenses raised in this civil matter upon conclusion of the criminal trial presently scheduled for January 27th of 2025. In other words, what they're saying here is that the prejudice to Ms. Reed being forced to take the time to litigate this civil case in the next 3 months, the prejudice to Ms. Reed far outweighs any prejudice to the plaintiffs. They're only going to have to wait 3 months, and the court has already said this case will probably not even conclude by August of 2027. And also, those deadlines are often extended, so these cases take forever. And you should just freeze this one. Just put it on hold. Put it on ice. till this trial's over. On the other hand, without a stay, Ms. Reed will be forced to decide between exposing herself to a procedural default or waiving her Fifth Amendment rights. Ms. Reed is not merely under criminal investigation. She has been indicted, mistried, and now awaits a second trial. The basic filing of a responsive pleading to the complaint alone could compromise Ms. Reed's defense against criminal prosecution. That's a great point. Even just filing an answer could compromise her defense in the criminal case. C. J&G Foods v. Eaton, which says the defendant has now been indicted, so exposure to criminal liability cannot be considered a possibility. It's a reality. Attached as Exhibit A. The potential burden and harm to Ms. Reed significantly outweighs the inconvenience to the other parties of a time delay. Thus, on balance, these factors favor a stay of the civil case. B. Public interest and the interests of non-party witnesses favor a stay. The public and non-party interests surrounding this case weigh in favor of a stay. There is a significant public interest in providing criminal defendants with a fair trial and protecting their constitutional rights. While the public interest is also served by providing plaintiffs and defendants an efficient forum to resolve civil matters, this civil action can still be fairly litigated within the time frame set forth in the attached tracking order despite a stay. Exhibit B. The public interest, therefore, favors a stay of the civil case. Non-party witnesses will similarly benefit from a stay. It is anticipated that many witnesses will testify at the upcoming criminal trial. The same witnesses' testimony may also be relevant to the parties' arguments and defenses in the civil litigation. If the civil litigation proceeds and overlaps with the criminal trial, these witnesses could conceivably be subjected to testifying on the witness stand while simultaneously being called for deposition and civil discovery. This would place an unfair burden on both the witnesses and the parties in both the civil and criminal litigation. Thus, this factor also favors a stay of the civil case. It's another good argument. C. The overlap with the criminal case and procedural status of both cases further warrants a stay of the civil proceedings. The allegations and issues in the criminal case directly overlap with the issues in the civil case. The decedent, witnesses, and evidence are the same in both cases. Ms. Reed's second criminal trial is scheduled to begin on January 27th, 2025. A trial date has been assigned, and the Norfolk Superior Court will reach the criminal trial years in advance of the trial of this civil action. The tracking order for this civil action provides the parties with 2 years' time for discovery and 3 years' time for final disposition. See Exhibit B. Even with a stay, the parties will still be on track to complete discovery with the current deadlines. Thus, the overlapping issues and procedural status of the two cases also favors a stay. D. This civil action should be stayed in the interest of judicial economy. Ms. Reed's proposed stay serves in the interest of judicial economy. The stay will alleviate the court's burden of ruling on potential discovery motions and requests for protective orders should Ms. Reed decide to invoke her Fifth Amendment privilege. It is in the best interests of this court, the parties, non-party witnesses, and the public to allow this brief stay until Ms. Reed's criminal trial concludes. Thus, judicial economy also favors a stay of this case. Conclusion. The competing interests and relevant factors all weigh strongly in support of a stay of the civil action pending completion of Ms. Reed's criminal trial. In light of the foregoing, the defendant, Karen Reed, respectfully requests a stay of all proceedings in the above captioned matter until the conclusion of her upcoming criminal trial in Norfolk Superior Court, which is presently scheduled to begin on January 27th of 2025. And so I think that is a very good argument that they make, which is 4 prongs. All good reasons. Very brief stay. It should be granted. I don't see any reason why it wouldn't. It's a very common motion when there's a criminal case pending and a civil case pending. Next, let's go to the exhibits. See if there's any questions with regard to the things that I just read first. Marissa, thanks for becoming a new member. Cam, thanks for being a member for 4 months. What did they allege? That the bar was liable for Karen's alleged conduct because they served her too much alcohol? Yeah, it's called a dram shop case. Assuming what they allege is true, still would break the causality chain. This is the civil case. So if you didn't watch Cam, I know that you just graduated law school and took the bar, and I guess you're waiting for your results, right? You should go back and watch the stream that I did on the civil case because I broke that down and all of the causes of action therein. So thank you. Hal, welcome. And May became a new member also. Welcome to you. Chem lady, keep on keeping on. The case that never ends. Yep, sure is. John O'Keefe's brother's DUI accident should be brought up in civil court. I don't know. I don't know if that would come in. I don't know. Depositions in civil cases are very, very broad. You can pretty much ask whatever you want, and all objections are preserved for the time of trial, but they could ask him about it in the deposition for sure. Probably, most likely they will. Hello, Ms. Buckeye 99. Love it here every day. Oh, thank you. Thank you so much. Love having you here. Love having all of you here. Let's take a look at the exhibits. That was number, let's see. All right, come on. Come on. Here are the exhibits attached to the motion. Everyone who's here, please hit the like button or I will turn off the air conditioning. I will turn off the air conditioning. All right, here's the exhibit list. They attach the cases, which is a very nice thing to do for the judge, which we do not need to read. And this is the scheduling order in the court docket of Mass courts with regard to this civil case pending in Plymouth County, Massachusetts. And here is the scheduling order, or their guidelines. And you can see here that the judgment or verdict or whatever, they expect this entire case to be wrapped up by 8/26/2027. With a final pretrial conference date of 2/12/2027. And all of these dates, most of which are after the criminal trial date. Common motion, like I said, there's no reason why it shouldn't be granted. So there's the receipt on that. And then they also, let's see. Was docket number 19. $18.19 was the exhibits, right? So number 20 is O'Keefe's opposition to this motion. Which is interesting because the opposition to the motion and the motion were both filed with the court on the same date. even though that motion by Karen Reed's defense attorneys in this civil case was dated September 19th. Okay. Let's read the O'Keefe's opposition to this motion. This is now the plaintiff's memorandum of law in opposition to defendant's motion to stay the civil proceedings. I'll allow it. I'll allow it. All right. In the instant motion, civil defendant Karen Reed seeks to stay civil discovery largely because Ms. Reed's ability to vigorously defend herself from criminal prosecution will be substantially prejudiced should this civil litigation proceed while her criminal trial takes place. And because the privileges afforded to Ms. Reed under the Fifth Amendment would be substantially impacted should this action proceed while the criminal prosecution is ongoing. Additionally, Ms. Reed claims the only potential prejudice to the plaintiffs is the inconvenience of a brief time delay. In certain cases, we may agree. Here, however, Ms. Reed consistently and voluntarily disregards her Fifth Amendment privilege as she attempts to craft her own narrative and poison. Hold on, I got to get this in continuous scroll before we get through this. She attempts to craft her own narrative and poison the jury pool in both the criminal and civil cases. Karen Reed has spoken publicly in interviews that we know of with NBC's Dateline, ABC's Nightline, ABC's 2020, Vanity Fair, NBC's Today, and a yet to be disclosed Netflix documentary. In light of her open willingness to speak publicly, Ms. Reed's current reliance on her Fifth Amendment right to silence appears to be less about avoiding self-incrimination and more about controlling the narrative to suit her interests. The court, in its discretion, certainly should not reward her ulterior motive of self-promotion. Hold on a second. I'm so spun by that. I haven't read this yet. So that is a whack argument. Okay. Let's cover that again. Here's their argument. In light of her open willingness to speak publicly, Ms. Reed's current reliance on her Fifth Amendment right to silence appears to be less about avoiding self-incrimination and more about controlling the narrative to suit her interests. The court, in its discretion, certainly should not reward her ulterior motive of self-promotion. The right to self-incriminate does not come with the right of self-promotion. Wow. Them some fighting words, huh, plaintiffs' attorneys? Because here's the thing. If Karen Reed did file an answer to this lawsuit, it is highly likely, I would be willing to bet, that she would file a third-party complaint against some of the people that the O'Keefes consider to be their friends. They would be third-partied into this lawsuit, and they would have to pay for defense attorneys, and that could come at great cost and great expense because likely they do not have insurance that would cover them during this such claim. So, in your hyperbole here, what you are actually doing is putting some of the O'Keefe's friends at risk, civilly, financially. Okay, if you want to do that, go ahead. But again, it's likely this is going to be granted. It's a very short delay. And you can bet that the discovery deadline in this case is not until August of 2026. Depositions would never even be happening in the next 3 months. They just wouldn't. Legal standard. The movement carries the heavy burden of establishing that a stay is warranted. You see Microfinancial citing Austin. It is well settled that the Fifth Amendment privilege against self-incrimination applies alike to civil and criminal cases. Testimony given in a civil deposition does not waive Fifth Amendment privilege for purposes of subsequent criminal trial. Nevertheless, there is no constitutional requirement that a civil proceeding must yield to a criminal one, even in the presence of a defendant's perceived need to assert the Fifth Amendment privilege. See Harriot, which says, apparently, the U.S. Constitution rarely, if ever, requires a stay of civil proceedings pending the outcome of criminal proceedings. Okay, well, it doesn't require it, but it's certainly within the judge's discretion, especially when it's such a short delay. Rather, the decision to grant such a stay requests in the sound discretion of the presiding judge, requiring a particularized inquiry into the circumstances of and the competing interests in the case. Courts must weigh any prejudice to the civil litigants which might result from granting a stay against the potential harm to the party claiming the privilege. Okay, well, that's interesting. Please tell us what the prejudice to Paul O'Keefe, Mr. and Mrs. O'Keefe, and Kaylee the niece is. What's the prejudice? I can't wait to hear it. The rights of the parties to the civil action are to be considered as equal. Justice is meted out in both civil and criminal litigation. The overall interest of the courts that justice be done may very well require that the compensation and remedy due a civil plaintiff should not be delayed. 2. Summary and facts of procedure. A simplified summary of facts introduced at the criminal trial and the procedural history is as follows. Okay, like all this is true. Defendant Karen Reed consumed 9 alcoholic drinks over approximately 3 hours at 2 Canton bars. Reed and her boyfriend, John O'Keefe, left the Waterfall bar and Reed proceeded to drive drunk. She transported O'Keefe from the bar to a house party in Canton. After dropping off O'Keefe, Reed backed up her Lexus and struck O'Keefe, who was knocked down and left to die in blizzard-like conditions. The lengthy criminal trial ended in a mistrial. In an affidavit filed by defendant's own criminal counsel in Norfolk case number, 8 of the deliberating jurors favored conviction on the same counts that overlap with plaintiff's claims in the civil matter. See affidavit of David Yannetti. Plaintiffs filed the instant action on or about August 26 of 2024. Argument. The estate has great reason to pursue civil justice against Karen Reed for wrongful death, whereas 8 of the 12 jurors, uninfluenced by the media circus, when tasked with resolving the facts under the higher standard of proof beyond a reasonable doubt, believed that Reed was guilty on OUI manslaughter. Our civil case only requires 5 of 6 of the jurors, when tasked with resolving the facts under the lesser standard of proof, more probable than not, to hold Reed liable. Any 2 of those criminal jurors who maintained no there could easily have been persuaded to change to a yes vote in the civil case here. Okay, I don't know. This could be one of the most ridiculous arguments I've ever heard. Okay, so are you agreeing then, plaintiff's counsel, that Karen Reed was acquitted on charges 1 and 3? Are you agreeing to that? And now you're gonna twist this argument, which, by the way, is up at the SJC waiting for resolution, to use it in this motion? I think it's misplaced and misguided, but you do you. It's not difficult to imagine 2 of the no jurors being persuaded by the deliberating jury, but it's a completely different jury in a completely different county with a completely different standard of proof and a completely different set of facts that's going to come out during this civil case, but okay. It's not difficult to imagine 2 of the no jurors being persuaded by the deliberating jury that Reed's drunk driving more likely than not caused O'Keefe's wrongful death. Anyone familiar with the O.J. Simpson case understands that there can be disparate outcomes with similar sets of fact, not only because the civil standard is lower, but also now the jury gets to assess the credibility of the alleged wrongdoer or the credibility of your biomechanical engineer that you're going to hire to prove that this accident happened the way that you're now going to say it did, that Karen Reed backed up into John O'Keefe. Wonder if they'll call Trooper Paul as an expert. Plaintiffs here are entitled to civil discovery, including the under oath testimony of defendant Reed, not only to hear her version of events, but also to assess her credibility. Plaintiffs noticed Reed's deposition for December 5th of 2024. Oh, that's interesting. I didn't see the notice of deposition anywhere. Guess it wasn't filed with the court. Yeah, good luck with that when the discovery deadline is not for, nearly 2 years from now. Despite her contention that proceeding with civil discovery could compromise her defense in the criminal prosecution, Reed has repeatedly emphasized that she wants to talk and is eager to provide her account of the events in question. Indeed, she has addressed the matters publicly on several occasions, making her own narrative a prominent part of the public discourse. Moreover, there is no shortage of reporters, bloggers, and persons claiming that Reed is actively speaking about the facts. This public engagement raises troubling questions about Reed's true intentions. If Reed genuinely has concerns about her statements being used against her, it seems contradictory she would continue to speak out so openly. Isn't this an interesting monologue? By actively participating in public discourse and potentially profiting from media engagements, Reed effectively forgoes any claim of Fifth Amendment protection. That's not accurate. Karen Reed's choice to speak out starkly contradicts any suggestion that she's concerned with self-incrimination. Now, Reed comes here asking this court to allow her to have it both ways. Furthermore, the O'Keefe family has compelling reasons to pursue their claims with urgency, as there are legitimate questions in this case regarding witness and jury manipulation. Oh, here we go. I mean, if you want to talk about jury manipulation, let's talk about having two of the third-party culprits sitting behind the family during closing arguments to stare down the jury. That could be considered potential jury manipulation, considering that neither one of those two men, IYK, had a personal relationship with Boston police officer John O'Keefe. Witness manipulation? Who's manipulating witnesses? Notice it doesn't say intimidation, it says manipulation. The rubber duckies. Further delay not only affects witnesses and jurors, but also the O'Keefe family, who have been dealing with the loss since January 29th of 2022. The first criminal trial extended beyond a full calendar month. It was actually 9 weeks. And the second trial is not set to begin until more than 4 months from now. It's 3 months, actually. Less than 3 months. Furthermore, there is no assurance that additional delays, another mistrial, a lengthy appeal, or other legal complications will not arise, extending Reed's authority to postpone the civil proceedings. If she chooses to plead the Fifth Amendment in the civil proceeding, she may do so with consequence. However, if she wants to speak under oath as freely as she does for the media and others, plaintiff welcomes the opportunity to obtain her testimony. By allowing the civil case to proceed, the court demonstrates a commitment to transparency and the timely resolution of such serious matters, which is crucial to maintaining public trust in the legal system. The public trust in the legal system in Massachusetts is severely waning, so there's that. I don't know. You guys can tell me what you think. A stay would only delay justice and could foster frustration among the public, who are closely watching both proceedings and expect the court to take decisive action. Public's confidence in the legal process depends upon seeing justice served in a prompt and effective manner. Denying this stay ensures both the civil and criminal matters are addressed on their own merits without unnecessary postponement that could undermine public faith in courts' ability to handle such high-profile and sensitive cases. Conclusion. While Karen Reed argues that civil discovery should be stayed to protect her Fifth Amendment rights, her actions say otherwise. By openly discussing the case in various media outlets, Reed demonstrates a clear intention to influence public perception and poison the jury pool in both her civil and criminal cases. This selective invocation of her rights undermines the very protections she seeks and raises serious questions about her motives. Under the circumstances, it is reasonable to proceed with civil discovery, allowing both parties to pursue their interests while ensuring the judicial process remains fair and balanced. XOXO, plaintiff's attorney, Mark Diller, Diller Law, Boston, Mass. Oh, okay. Well, let's let's take that down for a second. Let me just say that in my experience as a plaintiff's lawyer for over 30 years, I will say that typically most of my friends are defense attorneys. You see the same defense attorneys on cases throughout the years. Many defense attorneys represent certain insurance companies, so you see them all the time in court. They usually have typically friendly relationships. They agree to things, they stipulate to things. In many cases, this would just be stipulated to by the attorneys, but not here. No, no, not here. They're actually going to fight this and ask that the judge deny the stay on the basis that Karen Reed has spoken to media outlets and therefore she should waive her Fifth Amendment privilege in the civil case. It's an interesting argument, but what I really, really want to see is the motor vehicle accident report with respect to this motor vehicle accident that the plaintiff's attorney is claiming occurred. Because so many of my friends in the chat are or have been insurance adjusters, bodily injury claims adjusters, and property damage claims adjusters for automobile accidents. And would you pay on this claim? There is no motor vehicle accident report. There is no proof that he was actually hit by a car. Kevin, the Sallyport camera. They're pushing ahead pre-conviction because they feel she will be acquitted, which will make a civil case much more difficult after the fact. That's true. That's true. But they didn't hesitate to point out the O.J. Simpson case in which he was acquitted in the criminal case and then he was found liable in a civil case. So maybe by pointing out the O.J. case, they are conceding that she will likely be acquitted in the criminal case because why else point out O.J., right? Where are my BI claims adjusters in the chat? Amy Lou, thank you for your super sticker. Auntie Bev's verdict form says, I'll allow it. Lit my stove this AM. Good morning to Canada. Thanks for being a member for 5 months. Diplomatic Diva is a new member. Welcome, welcome. David Reese, just so you know, you pronounce Guarino correctly. I know I say Guarino. Somebody told me no, it's Garino. Thank you. So you're saying I'm right. Guarino. Thank you. Trooperino. Charlie Lynn, thanks for the 10. These folks need therapy so badly. This lawsuit is nothing but a load of unsubstantiated conjecture and contempt personified. What did I say? People file civil suits for 2 reasons: money and revenge. Many people file medical malpractice suits against doctors just because their doctor didn't say, I'm sorry. There is nothing that can be done to turn the clock back, to bring Officer John O'Keefe to life. The only thing a civil suit will do is maybe, if you win or it settles, get you some money. Or if you really want revenge against a person, it's a great way to try and do that, even if the case doesn't have a whole lot of merit, maybe, potentially, in my opinion. Chloe Albert's revenge, thanks for the 5. Anyone appreciate the irony of this? Karen is being accused of being a drunk and unaliving someone by people who are actual drunks and unalivers. That is your opinion, Chloe Albert's revenge. Thanks for the 5. Are they pro se? Charlie Lynn, no, they are not. They have Karen has defense attorneys that are hired by her auto insurance company to defend her in this case. She does not have to pay them. They are paid by the carrier. Plaintiffs' attorneys are also not paid. They take cases on contingency, so they don't recover unless the case settles or goes to verdict, and they eventually get paid if the case settles or goes to verdict. They don't get paid by the hour. Ocean is like, nothing surprises me anymore. Wildman's mom says, OJ was guilty, Karen's not. Big difference. Emma Max says a lot of the OJ evidence had lots in the public thinking he did it too. In this case, it's the opposite. And so there you go. Let's see. We also have request for a hearing. Actually, let's take a look at this first. The affidavit of compliance, which I imagine is a requirement under Massachusetts civil procedure rules. And this is the affidavit of compliance filed by Karen Reed's defense attorney in this civil case. Let's close some tabs, shall we? Here's the affidavit of compliance with Superior Court Rules 9A and 9C. William L. Cavill? What should we call him? Cavill? William Cavill Jr., do hereby swear under penalty of perjury as follows. I'm an attorney practicing with Mellick and Porter, representing the defendant, Karen Reed, in the above captioned action. Pursuant to Rule 9C, I communicated with counsel for the plaintiffs regarding the issues raised in the defendant's motion to stay the civil proceedings via telephone on or about September 16th of 2024. Parties were unable to narrow the areas of dispute regarding the defendant's motions to stay the civil proceedings. Okay. Sometimes that's called a meet and confer before you file a motion. In some jurisdictions, you are required to meet and confer, meaning, can we resolve these issues without involving the court? Can we stipulate that we'll just stay discovery until after the criminal case is over? Or, at some later date, let's say they would say, for now, we'll stipulate that discovery could be stayed until March 1 of 2025. But apparently he communicated with plaintiff's counsel and they would not agree. On or about September 19th, 2024, my office served the plaintiffs through counsel via email and the co-defendants via first-class mail with the following documents. Defendant Karen Reed's motion to stay civil proceedings pending resolution of criminal trial. Memo of law in support of defendant's motion to stay, both of which we read together. And exhibits A and B. On or about September 19th, 2024, my office spoke with counsel for Waterfall Bar and Grill regarding the defendant's motion to stay the civil proceedings and provided a copy of same to counsel via email. On or about September 30th of 2024, I received plaintiff's opposition to the defendant's motion to stay the civil proceedings. As of this date, no further oppositions have been received by this office. Counsel for each co-defendant advised that they are not taking a position on the defendant's motion to stay. All requirements of Superior Court Rules 9A and C have been met. That was signed on October 2nd by William Cavill Jr. And all of this was filed with the court just yesterday. Interesting. So neither bar is taking a position here. They don't oppose the stay. And then they're also requesting a hearing. I don't know if it will be televised. I don't know if they'll get cameras in civil court, do they? Which merely says, pursuant to Superior Court Rule 9A C2, defendant Karen Reed by her counsel respectfully requests a hearing on her motion to stay civil proceedings pending resolution of the criminal trial. Again, the court could also enter a temporary order and say, okay, well, we're going to temporarily stay until pick a date in early 2025. That would be after this criminal trial was over. And really, no harm, no foul. Mike B from the 413, good morning, and thanks for the 10. Something I have found strange is no local or state regulators have attempted action against the bars yet. No, I don't think they will. There's no evidence. Plus, the Massachusetts social host law would apply to Brian Albert if injuries aren't from a car. I don't know. Could be. I don't think Brian Albert gets in trouble for anything. Some guy with cancer. Thanks for the 5 and sorry about the cancer. This lawsuit was written by Grant Smith Ellis and some attorney signed it. We have an official Karen Read playlist. We do, Phoebe. We have it. I don't know where it is right now. It's linked in some of the trial streams, I think. Go back to the trial streams. Maybe you'll find it in the description. Let's go to the court website for a second and see if we can find out if anything else has been filed today. And if there's even a judge assigned to this yet. So any of you who are familiar with Superior Court in Plymouth, if you have any experience with any of these judges, let me know. Let us see. There's no judge assigned yet. There's no hearing set yet. And we have reviewed every single document that has been filed thus far. What say you, my friends? Melissa, why does she have different lawyers for this? Are civil and criminal attorneys different? I love you. Just a girl in Rockland, Mass. Yeah, this is a civil case. So yeah, civil and criminal attorneys are different, but because she's a defendant in this case and they're alleging that it involved her motor vehicle, that's why you have insurance for your car. Because if you're ever sued for an alleged car accident, your insurance company will appoint lawyers to defend you at no cost. So that is why. Typically, plaintiffs' attorneys do not defend civil cases. Typically, criminal defense attorneys do not prosecute cases criminally, except for Hank Brennan, who's been hired to prosecute Karen Read. And, typically, lawyers specialize in something. I was a plaintiff's attorney. And if my client came and said, "Can you write my will?" I would say, "Would you go to a veterinarian to give your kid stitches?" You just wouldn't. You go to a lawyer who writes wills, a trust and estates lawyer. So, yeah, they're different. They're different. And the FBI disagrees with the evidence, says Charlie Lynn. Thank you, Mamacita, for your intel on the Plymouth judges are fair. My kids have won against every nonsense charge they've had. Well, that's criminal. I don't know about the civil side, but thank you for letting us know. Archangel, no MBA report or pictures. Insurance getting a good laugh. You can change your name, Marissa, if you want to. Like Shock and Horror. You can change your name anytime you want. On YouTube. I don't know how to do it, but you can. Everybody does it. Anti-Bev's verdict form. Karen supporters will continue to help fund her defense. Truth wins. We got to quit. I don't think that you're going to need to because the insurance company takes on that burden. Melanie, would Karen Read be able to bring in the FBI evidence and crash daddies in the civil suit? Sure, her defense attorneys could hire them. Absolutely. That would be easy because they've already done the work. The work is already done. Charlene, yeah, I did pull that. I don't know if you were here earlier. I pulled up that article and we were talking about it. It has been said that it may have been Guarino that was injured in that accident by a drunk driver. You think it's his way to retire real quick? I don't know. I did talk about that in the beginning. I haven't been able to confirm or deny. Wild Man's mom says, "Oh, so Karen has no rights." Says all who want to hide the truth. Officer John O'Keefe was not hit by a car and she was not at fault for being beaten in the house. For his being beaten in the house she never went into. He was in the house. Thank you for your opinion. Wild Man's mom. Mindy, is it possible they want to get this in to stop Karen Read from being able to raise funds for her defense in the criminal case? I don't see how that would stop her from doing that. She's innocent. No need to worry. Everyone can calm down. Thanks, G5. That's true. I don't think there's anything to worry about here because I don't think any claims adjuster is going to settle this case. Insurance companies like to hold on to their money. They don't do quick settlements, unless it's a slam dunk kind of thing. And this is certainly far from it. Vicky Joe, crazy to keep up this charade. I think it's only to pile more onto Karen due to hate. I'm praying that the truth is found and they can see and heal from it. Mm-hmm. Nolene says they were hoping for her auto insurance would settle after the expected guilty verdict. LOL. I'm here for the deposition show. Scott McGinnis. Well, a stay would only make sense. So therefore, it will be denied in the upside down world that is Massachusetts. Hi, Scott McGinnis. I don't know, I think it has a good chance of being granted, but again, I'm not familiar with the civil court judges in Plymouth County. Doesn't seem to be prejudicial. And the argument that Karen Reed doesn't care about her Fifth Amendment rights because she's given an interview to 48 Hours or 2020 is a little overly broad. Perhaps not really on point. Any more questions, my friends? Thoughts, concerns before we wrap this one? And I will teleport you to the afternoon stream at 12:30, which I will be covering that Kentucky judge shot by the sheriff. There's a lot more to that story. Redhead pointing out that channels want to help her and they weren't asked to do so, that people are collecting for Karen's defense fund. Anyone? Stephanie Sweedler, it's a bad constitutional argument by lawyers who are now stuck with a dog of a case. I mean, I think maybe they probably thought the carriers would just pay. I don't think so. And it certainly unites Karen Reed in her interests with CF McCarthy's and Waterfall, right? Because now if they come in and testify in the next criminal trial, they certainly have every reason to say we were not over-serving her. Whatever 9 drinks are in that video did not contain alcohol. Their interests are now united. That is why in my original stream that I did on this case, I said I did not think it was a smart idea for the O'Keefe's attorneys to file this lawsuit on behalf of the O'Keefe's now. They had until January of next year before the statute would expire. So what does this do other than stir the pot? Marcello, hello to Argentina. I don't wish anything good nor bad to the O'Keefe family. They decided to look the other way and act on wasting their money and energy for greediness. It's not costing them anything, but I certainly would not want to be in their position. I'm sure that the grief is overwhelming, but I would have waited to file this case. Cindy Wren, thanks for becoming a member. Debbie Blair points out the videos didn't even show her being served 9 drinks, whatever they happen to be. You are correct. We try to keep it classy. We try. Thank you for noticing. All right. Thank you to my moderators for keeping it as classy as possible today, this evening, this morning. I don't know what time of day it is anymore at this point. But going back to Hank Brennan, I don't know. It's crazy. Maybe they're just going to keep renewing Hank Brennan's contract every month because 300 hours is going to be gone pretty quickly. Does he want to run for district attorney? I don't know. What are your thoughts on that? Food for thought. Thanks, mods, for keeping it classy this morning. Thank you, everyone. And when I end this stream, you're going to be teleported over to the afternoon stream. So hit the notification over there if you want to come back and listen to all the stuff I have to say about that sheriff and the bombshell civil suit that was pending against him for things that were going on in the judge's chambers. that are pretty revolting. You may want to hear about that. So I'm going to teleport you there now. Come back and see me later. Thanks to the moderators for keeping it classy. And everyone, please hit the like button on your way out. Even if you're hate watching, hit the like button too. It doesn't hurt you. Be cool, be kind, be classy. Love you guys. See you at 12:30. Bye.